Welcome to Module 7, International Transfers. Moving data between countries has always been problematic, due to different legal and legislative frameworks. At the end of this module, you will have an understanding of the rules GDPR places on data transfers to other countries, the methods of moving data from an EU country to a non-EU country. When legislators were creating the GDPR, they decided to relax the rules on international data transfers that were part of the existing Data Protection Directive. What event in 2013 prompted the EU to review this, and subsequently put more rigorous measures in place? In 2013, Edward Snowden disclosed documents revealing details of global surveillance programs, many run by the U.S. National Security Agency, which went beyond the remit proposed by the U.S. Congress. The NSA were tapping worldwide communication traffic, much of which went via the US or the UK, and this prompted the EU to reconsider the controls necessary when moving data outside of the EEA. The GDPR is designed to allow free movement of data within the European Economic Area, EEA. There are very few restrictions on data transfers within the EEA. For example, there are notification requirements for the movement of tax information, and in some cases data transfers involving national security and defense are restricted. Note, the EEA consists of the 27 members of the European Union, and 3 members of the European Free Trade Associations. To move data outside of the European Union, it is necessary to justify the transfer. This can be accomplished by using one of 3 options. These should be considered in the order specified, i.e., adequacy decision, appropriate safeguards, and finally, derogations. An adequacy decision is granted to a country by the European Commission where it has been determined that the country has the same level of data protection as the European Union. Examples of countries with adequacy decisions are New Zealand, Canada, Switzerland, and Argentina. Whilst the UK is no longer part of the EU or EEA, and has not yet been granted an adequacy decision, the EU-UK Trade and Cooperation Agreement contains a bridging mechanism that allows the continued free flow of personal data from the EU-EEA to the UK, after the transition period until adequacy decisions come into effect. Note, the UK government is recommending that businesses that transfer personal data work with the relevant EU-EEA organisations, to put alternative transfer mechanisms in place, to safeguard against any interruption to the free flow of personal data from the EU to the UK. The US does not have an EU adequacy decision, however, data transfers from the EU and Switzerland were allowed to US organizations via Privacy Shield, which gave the required level of protection of personal data. However, on the 16th of July 2020, the European Union Court of Justice invalidated the EU-US Privacy Shield in its decision in Facebook Ireland versus Schrems. The court determined that the Privacy Shield transfer mechanism does not comply with the level of protection required under EU law. This ruling was upheld by the Swiss Federal Data Protection and Information Commissioner. Whilst there is still an obligation on organizations currently using the EU-US Privacy Shield to fulfill their obligations, it does require that transfers of EU-Swiss data to the US are secured using alternative mechanisms. Where countries do not qualify for an adequacy decision, they need to use an alternative mechanism to provide appropriate safeguards for EU citizen data. These include binding corporate rules, standard contractual clauses, approved codes of conduct. To be valid, an appropriate safeguard must be approved by a supervisory authority. Where a country cannot provide either an adequate level of protection or appropriate safeguards, they must try to use a derogation provided in the regulation, for example consent, contract, non-repetitive transfers, etc. Derogations are more difficult to apply and need careful justification. One of the biggest challenges faced by global organizations operating in the European Union is international data transfers, and finding the right mechanism to allow data movements of EU citizens' data can be onerous and time-consuming. However, despite technology developments and greater globalization, it is unlikely that the EU will relax its approach in the foreseeable future. We will now ask you a short question. Some time will be left for you to think about the answer. However, feel free to pause the video after the question is asked to allow yourself enough time to think about the answer. You do not need to fill in the boxes to provide your answer. The answer will be given shortly after the question has been asked. Number the following data transfer mechanisms in order of priority, best to least preferred, if a company wants to move personal data from one country to another. An adequacy decision. Appropriate safeguards. The receiving country is a member of the EEA. A derogation. One. The receiving country is a member of the EEA. 2. An adequacy decision. 3. Appropriate safeguards. 4. A derogation. This is the end of our Module 7, International Transfers. You can now move on to Module 8, Controllers and Processors.